Hi, everyone. Thank you for attending today's session, Employment Law Post-Pandemic. Today's session will run about 45 minutes with time at the end to answer questions. Please post any questions in the chat box. We have received a tremendous response to this webinar and are hosting a large audience. If you experience technical difficulties, we suggest you exit the meeting and re-enter it using the link provided in the email. Rest assured that LexisNexis will distribute a recording of today's session in a follow-up email. I am your moderator for today, Monica Sorensen. I am the print marketing manager here at LexisNexis Canada. Now we will meet today's presenter. Sean J. O'Donnell is an advocate with extensive experience in employment, human rights, and civil litigation. He is the founder and principal of SJO Legal Professional Corporation based in Toronto. Sean combines his passion for employment and human rights law with his Bay Street litigation experience to provide advice and advocacy to both employers and employees. He has represented clients at various Ontario tribunals and federal courts across Canada and has litigated matters at all court levels in Ontario, as well as the Supreme Court of Newfoundland and Labrador and the Supreme Court of Canada. He is also the author of Employment Law During a Pandemic, published by LexisNexis Canada in 2022. I will now turn it over to Sean.
Thank you very much, Monica, and thanks for putting on this webinar today. So I'll just dive right in with a quick summary of what we're going to be talking about today. So these are the general topics that we will be discussing. So wrongful and constructive dismissal, mitigation of damages, human rights issues, occupational health and safety issues, and also vaccination issues. So we'll start with wrongful dismissal or wrongful termination. So what is a wrongful dismissal? It's a termination without just cause. And as long as there is compensation in lieu of working notice or reasonable notice, the employer has complied with the common law. This applies where the time periods under Section 56 sub 2 of the Employment Standards Act have elapsed. And there are two things that the employee is entitled to claim, both notice and severance pay, statutory severance pay under the Employment Standards Act. And also subsumed within that is common law reasonable notice. If there's no written employment contract or no enforceable termination clause limiting the employee to their Employment Standards Act minimums. And one of the issues that we started seeing fairly early on during the pandemic or towards the beginning of the pandemic was the effect that COVID-19 or the pandemic had on common law reasonable notice. And I've laid out some snippets of decisions, both in the slide and in the notes. So one of the first cases was Hunsley and Canadian Energy Services, a case that came from Alberta. In that case, the employee was entitled to 8 months of notice. They were dismissed without cause in September of 2019, not because of the pandemic, strictly speaking, but due to financial challenges in the oil and gas industry that preceded the pandemic, which was then exacerbated by the pandemic. And the court in that particular decision held that economic conditions can be considered under the availability of similar employment, Bardal factor. And as you can see, the court went on to say that adverse economic conditions tend to increase the notice period because it's harder to find employment during a pandemic or when the economy is depressed. But the key issue is what is the economic state at the time of the dismissal, not what happens after the dismissal. And I'll go on to some other slides in a minute, but I'd just like to talk about some more recent decisions. And so there was a decision that came out this year in Ontario, the Millwood and IBM decision, which you can see in the notes. So again, the court talked about or took judicial notice rather of the declaration of the pandemic in March of 2020 and the emergency measures put into place and the impact that this would have on the plaintiff's ability to mitigate their damages. The notice period in that particular case, and we'll see this through the other cases as well, it wasn't increased by very much. It was essentially increased by 1 month. Another few decisions here as well. La Montagne and J.L. Richards. This is from 2021. Again, the employee's notice period was only increased by 1 month, so not a significant improvement there. There's also the Williams and Air Canada decision from 2022 in Ontario. So Ms. Williams was terminated as a result of the pandemic, and the court again said that yes, obviously the pandemic is a factor that may lengthen an employee's notice or notice period. Going back a little bit to some of the more earlier decisions, there's the Yee and Hudson's Bay decision from 2021. This particular employee was very diligent with their job search and made 90 job applications without any success. So the court looked at those particular circumstances and relied on an Ontario Court of Appeal decision from 2015, the Holland decision, saying that notice is to be determined by the circumstances existing at the time. There's also the Kraft decision from 2021. This employee was terminated in the second week of March 2020, so it was just before the declaration of the pandemic. But the court took notice of the fact that the economy was already shutting down, and obviously did remain closed during the employee's job search. Got another few decisions in the notes as well. So Lopez and Gonzalez, this is a little bit more recent from 2022. So an 11-year employee, 59 years old, they were awarded 12 months of notice. And Justice Perel held in this decision that the COVID-19 pandemic may justify a longer notice period because of the difficulty in finding comparable employment. There's also from New Brunswick, the Miller and Luminutra decision. Another decision, Sandham and Diamond Yates Wine. So this particular employee was awarded 24 months notice, which is sort of an unofficial cap in Ontario. And this person had 22 years of service. And as you can see from the last decision in the notes here, Snyder and Riotech, a 42-year-old construction laborer with 2.5 years service was awarded 4 months and got a slight bump due to COVID of 2 weeks. So not very significant, but it's an issue. I've got a couple of slides here talking about Kraft as well, which I've already covered, and Iriotakis as well. I mean, you see the same comments in all of these decisions, basically that there is an extension of the notice period due to COVID, but it's not very much. In Russell and the Brick Warehouse from 2021 in Ontario as well, the court was asked to opine on whether the pandemic was an extraordinary circumstance, and which would justify a notice period beyond 24 months. They actually declined to extend the notice period, holding that the pandemic was not an extraordinary circumstance, which was a bit surprising. So, I mean, the conclusions that we can glean from these cases on whether the pandemic results in a longer notice period is that yes, it does justify a longer notice period, but only where the dismissal occurs after the economic effects of the pandemic where it first arose. The factor shouldn't be given undue weight. The pandemic was not an extraordinary circumstance justifying a notice period beyond 24 months. And obviously, as we've seen from the cases, the increase is nominal from 2 weeks or a month or so. So moving on from constructive dismissal to sort of related topic from wrongful dismissal to constructive dismissal. So the leading case on constructive dismissal comes from the Supreme Court of Canada. It's the Potter decision. And in the Potter decision, the Supreme Court talked about two different branches of constructive dismissal. And this is something I come across in my practice a lot. So the first branch is a single unilateral act breaching an essential term of an employment contract, the most common one being a significant reduction in pay. The second branch really relates to the employer's conduct, and in that they evince an intention to no longer be bound by the employment contract. And so, when employees feel that they've been constructively dismissed, they have a few options in terms of what to do. And we get guidance on this from the Court of Appeal in the wrongful decision from 2008. So the first option is the employee can accept the change, in which case their employment continues under the new terms imposed on them. Their second option is to reject the change, allege constructive dismissal, and sue for damages if the employer treats the change as being in effect. And the third option, which is the most common one in my practice, is that the employer rejects the change. Then the ball is in the employer's court. You can either terminate the employee and offer reemployment on new terms, or if the employee is not fired and they continue to work, the employee can insist on adherence to the original terms before the unilateral change. And one of the hot button issues, and it still is a big issue throughout the pandemic, and even now today, is about temporary layoffs and constructive dismissal. So a temporary layoff is a constructive dismissal when certain conditions are satisfied. So one of those is there's no layoff provision in the written employment agreement between the parties. There's no written agreement to the layoff in advance, and where it's for longer than the time periods outlined in Section 56 sub 2 of the Employment Standards Act. And they're laid out on the slide here. So basically, a layoff that's not more than 13 weeks in any period of 20 consecutive weeks, or a layoff that is more than 13 weeks in any period of 20 consecutive weeks, and less than 35 weeks out of 52 weeks if the employer satisfies certain conditions, which you can see there. The most common one that I've seen that's satisfied is that the employee's benefits are maintained during the layoff. And there was a regulation in Ontario that came into effect that I'm sure everybody's aware of, the Infectious Disease Emergency Leave, or OREG 228 of 2020. So this was a regulation under the Employment Standards Act, which came into effect in May of 2020. It's been extended several times, and it did actually expire in July of 2022. So what is an infectious disease emergency leave, and why is that important? So it's an unpaid job protected leave where a non-unionized employee has been temporarily laid off due to the pandemic, or has otherwise had their wages or hours significantly slashed or eliminated because of the pandemic. And the idea was that these employees would not be considered to be constructively dismissed for the purposes of the Employment Standards Act. And we'll get into that a little bit more in a moment. And any temporary layoffs that extend beyond the time limits in Section 56 sub 2 are not deemed terminations while the regulation was in effect. Any claims that were brought to the Ministry of Labour very early on, there were quite a few, alleged constructive dismissal, were automatically dismissed under this regulation. So what about the common law? And this is where things get interesting because there are where decisions going both ways. So the first decision on the slide here is Coutinho and Ocular Health. And this was May of 2020. The employee was placed on an infectious disease emergency leave pursuant to the regulation we just talked about. The employee sued, and the employer moved for summary judgment on the basis that the regulation barred her common law right to damages for constructive dismissal. And the employer lost on the summary judgment motion. And so essentially the judge, Justice Broad, held that the common law right to access civil remedies flowing from a constructive dismissal was not impeded because of the regulation. And you can see the quote there: no civil remedy of an employee against his or her employer is affected by this act. And that's just a quote from Section 8 sub 1 of the Employment Standards Act. There have been other decisions on this, as I've alluded to, so I'll maybe just skip ahead a little bit before coming back to the notes. So this next decision, Taylor and Hanley, went the complete opposite way and was heard in the Court of Appeal recently, and we'll get to that in a moment. But this is a decision from 2021 related to a Tim Hortons employee who was laid off in March of 2020 because of the pandemic and was actually recalled to work in September of 2020. So the employee sued the employer for constructive dismissal, making the same argument that the regulation did not displace her common law rights. And Justice Ferguson, quote from Justice Ferguson here, that who held that the analysis in Coutinho was wrong, which was surprising to me at least. She held that the court was not bound by this because it was also a Superior Court decision. Even though we would be in a situation where there are conflicting decisions on the law, the court should not follow Coutinho if the court is of the view that it was wrongly decided. Justice Ferguson also held that deeming a temporary layoff as a constructive dismissal at common law, despite the regulation, offends the rules of statutory interpretation because it would essentially render the regulation meaningless. And as you can see on the slide, Justice Ferguson relied on a Court of Appeal case, Elsgood, to find that the Employment Standards Act displaces the common law. We'll move on a little bit here and we will jump back in a moment, but just very shortly after the Taylor decision, another decision was issued which followed Coutinho, and this is the Fogelman decision, where the court found that an employee can sue for constructive dismissal after being temporarily laid off under the regulation. And on the slide, it says that the Taylor appeal is being heard at the Ontario Court of Appeal in April of 2022. It has been heard and there has been a decision, and we'll get to that in a moment. So just skipping back to some of the more recent decisions on this issue in the notes, which I'll just expand a little bit. So there's a decision from 2022, the Miranda decision, where the employee was constructively dismissed, or the court held that the employee was constructively dismissed in March of 2018. And the decision relied on Coutinho. And there's the Wilkinson and Pharma decision as well from 2022, which upheld Coutinho, but the judgment was based on another reason. This was also a small claims court. Yes, so question as to the precedential value of this. And you can see in the notes there that the court held that the infectious disease emergency leave regulation didn't apply to this case because the dismissal occurred before the regulation. And we'll just get back to the Taylor decision at the Court of Appeal. As I've indicated, this was heard in April of last year. The decision followed pretty soon after, and there were essentially two questions. In this case, one was of broader importance to employers and employees and employment lawyers, I think, and the other was a little bit more narrow. So the first broader question was, do the infectious disease emergency leave rules under the Employment Standards Act overrule the notion that temporary layoffs constitute a constructive dismissal, and the employee is therefore entitled to common law reasonable notice? The second issue, which was more of a procedural issue, was whether a Rule 21.01 motion, which is a determination of an issue before trial, was the appropriate mechanism for resolving this case. And the answer that the Court of Appeal came up with was a bit disappointing for a lot of people. So the Court of Appeal essentially dodged the first question and sent the issue back for trial because they believed that their answer would not resolve the very fact-driven dispute between the parties, and they also didn't have a full record. So in my opinion, Futino and Fogelman, which have not been appealed, are good law. Taylor, the underlying decision in Taylor is not. There's another three decisions that are quite interesting. So towards the bottom of the notes, so Parmar and Tribe Management, this is a BC case where the BC court held that putting a non-compliant employee on leave for violating a vaccine mandate is not a constructive dismissal. In Alberta as well, there's the Binky and Loblaw decision where the employee was refusing to wear a mask. They were put on leave without pay, and the court held in this case that that is not a constructive dismissal. One case which did come out very recently is the FAM case, and this was an issue that's very interesting for me because I have a few cases I'm litigating right now where this is a live issue. So I believe this decision came out on April 13th, so not that long ago. Court of Appeal in this case overturned the trial judge's finding that because the plaintiff employee did not actively protest their layoff for 9 months, they therefore accepted the layoff and couldn't claim constructive dismissal. So what happened in this case was the plaintiff was laid off on March 20th at the beginning of the pandemic, and they retained a lawyer a few months later, 6 months later, 9 months later, who promptly sent a demand letter to the employer. So the Court of Appeal talks about the principles to determine whether an employee has condoned a layoff or not. So they're laid out here, but very briefly, the court held that signing a layoff letter does not indicate that you accept the legality of the layoff. They also talked about claiming constructive dismissal immediately after retaining a lawyer, evidence that the employee only discovered their claim of constructive dismissal when they spoke to the lawyer. Thirdly, employees have to be given a reasonable time to assess their legal situation. And this was a little bit interesting, the facts of this case, because the employee had been given a series of layoff notices, not just one. And the court held that they were entitled to take a wait and see approach to see whether they were recalled or not. There's a quote here from the court as well in terms of positive action on the part of the employee. So has the employee expressed that they are willing to return to work? That's also an issue. In this particular case, the employee was not actively at work during the layoff period. And so the court held that he could therefore not condone the change in his employment, which was kind of interesting. And lastly, the court held that there's no requirement for an employee to ask when they might be recalled before commencing an action for constructive dismissal. So moving on to mitigation of damages. One question that's come up is, will the courts take into account the pandemic when assessing mitigation efforts? And the answer is yes, most likely. And this falls under availability of similar employment. I have a decision on the slide here from BC. So this is the Mohammed and Dexterra decision. The court found in this case that economic factors arising post-termination, such as those from the pandemic, can be relevant, obviously, to mitigation if they impact the availability of finding equivalent employment. And I've got some more cases in the notes for the Holland case. So in Miller and Ontario Potato Distribution, the judge in this case took judicial notice of the fact that the plaintiff's ability to find alternate employment was adversely affected by the pandemic. There's a 2021 decision here as well, Pat and Pavlov. Again, the court indicated that it was a reasonable inference to draw from the evidence and the timing of the dismissal that the pandemic was an obstacle to finding a new job. Moving on in terms of mitigation to whether EI, CERB, and CRBs are considered as mitigation income that should be deducted. There's a case from 2017, actually, in the Ontario Court of Appeal, where Justice Gillese said that EI benefits are not to be deducted from damages awarded for wrongful dismissal. But a little wrinkle in that was the implementation of interim order number 8, which was an amendment to the Employment Insurance Act, so federal statute. So essentially, this interim order, the effect of this was that anybody who was dismissed on or after September 27 of 2020 did not have their EI entitlement affected. The interim order, I appreciate on the slide, it says that the interim order expired on September 25, 2021, was actually extended to September of 2022. So basically, any EI that was paid to a dismissed employee between September of 2020 and September of 2022 does not and did not have to be paid back, which is many may consider to be double dipping. And in terms of CERB, there are several decisions on this. I won't spend too much time on this other than to say, as indicated in the notes, that there are 2 persuasive Court of Appeal decisions from Alberta and also from BC to the effect that CERB is not deductible. So essentially, that's the answer on that issue. Moving on quickly to some human rights issues that arise because of the pandemic. We'll just move to the next slide. So one of the big issues that came up was discrimination on the basis of a disability. And obviously, pursuant to the Ontario Human Rights Code and the Canadian Human Rights Act, an employer cannot discriminate an employee on the basis of a disability. And this really comes into play in a few different ways related to the pandemic. So the first is infectious diseases. So the Ontario Human Rights Commission issued a policy statement in March of 2020, confirming that the code grounded disability is engaged in relation to COVID-19, as it covers medical conditions or even perceived medical conditions that can carry a significant social stigma. One of the other hot topics was mental health disabilities. So the question is it reasonable for employers to expect some employees to experience mental health challenges due to the pandemic? Yes. Many employees who were diagnosed with a mental health disability during the pandemic must be accommodated, as they always must be accommodated. There are other code grounds that are engaged related to Ontario, so race, ethnic origin as well. There were a lot of fears very early on in the pandemic that employees with East Asian backgrounds may face discrimination based on xenophobic descriptions of COVID-19. Family status concerns was another thing that came up quite frequently in my practice. So both family status and marital status. And this really came into play because, a particular employee may not be directly vulnerable to COVID-19, but they may have familial obligations to a vulnerable family member. So generally, the advice to employers on this issue is that they should allow employees to take reasonable leaves of absence to care for family members who have a disability or who are ill or who are elderly. And employers should also be attentive to the needs of employees who have parents because of school closures, etc. In terms of accommodating family status and disabilities generally, there are 2 components. There's a procedural component and a substantial component. So the procedural component is all about obtaining information and assessing potential accommodations. The substantial component is about offering the appropriate accommodations, but there is a limit obviously, to accommodation, and that limit is to the point of undue hardship based on the cost, any safety concerns, and any excessive disruption to the workplace. One issue that's arisen quite a bit is about telecommuting as an accommodation. This was very commonplace during the pandemic and still is, although a lot of employers are attempting to get employees to return to the workplace. There are advantages and disadvantages to this, but generally speaking, employers are not required to accommodate employees who simply prefer to work from home and who used to return to the workplace as the pandemic subsides. And I'll just touch briefly on some occupational health and safety issues as well. So a lot of this stems from the Ontario, specifically from the Occupational Health and Safety Act. And the employers in Ontario have a general duty or obligation to take reasonable precautions to protect the health and safety of its workers. In the context of the pandemic, employers were finding quite early on that workers were exercising their right to refuse unsafe work based on what they perceive as inadequate protections. Although the vast majority of these claims failed, if not all of them. And so this next slide in terms of work refusals discusses what employers have to do if employees make this type of claim. So firstly, they have to internally investigate the situation and then record the circumstances of the refusal in the investigation and ensure that any necessary action to remedy the danger is taken. In terms of advice for employers, a lot of this guidance came from the Public Health Agency of Canada. So these were things that employers could do to keep the workplace safe in the context of the pandemic. I'll just leave them up on the slide for a moment because I'd like to get to vaccination issues, which is a hot button topic. Okay, so as I've said, this is something that is a very sensitive issue in terms of the vaccination and mandating COVID-19 vaccinations in the workplace. So the big question was, and still is, I suppose, although there are a lot of decisions now, can employers mandate employees to be vaccinated against COVID-19? Going through the decisions, I've come to the understanding that this is quite a nuanced situation and requires an evaluation of each employment arrangement. So there's not a one-size-fits-all answer. And there's a difference as well. There's an issue as well with statutory mandates to vaccinate employees. So essentially that shifts the responsibility as to whether the vaccination policy is reasonable from the employer to the government. So I have an example here as well in Ontario where there was mandated immunization policies in long-term care homes. In May of 2021, employees had to do one of the following things. First, provide proof of vaccination. Second, provide a documented medical reason for not being vaccinated. Or 3, participate in an educational program about the benefits of vaccination and the risks of not being vaccinated. Also, you can see on the slide, the federal government in August of 2021 announced that it intended to make COVID-19 vaccines mandatory for federally regulated employees. And I'll skip over the notes on this one. There is a decision there, Public Health Subvariant Districts and Ontario Nurses decision. But what I'll likely do after the webinar is I have a chart of decisions in terms of vaccination policies, whether they were upheld to be reasonable or unreasonable and why. So I think after the webinar, what I'll do is I'll provide the slides, the notes, and also the chart, which may be helpful to some people, just because we're running out of time. But I will say that generally, this is what I've gleaned from all of the decisions in terms of vaccination policies. So first of all, we look at non-statutory mandates. These are the factors in terms of whether vaccination should be mandated or not, or whether it's likely to be upheld, the vaccination policy. So you first have to ask, are we talking about a potential employee or prospective employee or an existing employee? So obviously potential employees should be made aware of the vaccination policy before they accept employment. And obviously existing employees, they haven't had an opportunity to accept a vaccination policy at the start of their employment. And without cause, dismissals based on refusals to be vaccinated can be very costly. Second consideration is the employer's duty to maintain a safe and healthy workplace. So this goes back to the Occupational Health and Safety Act. And places an obligation on employers to maintain workplaces that are still safe and healthy. So things like social distancing, which we saw very early in the pandemic, and any vaccination policies are likely to be upheld if they are reasonable. Third issue or third factor to consider is the nature of the workplace. And so, it's difficult to justify imposing a requirement to be vaccinated on remote workers because they're not in the workplace. And health and safety in the workplace is therefore not an issue. For some workplaces, physical distancing and masking may be okay, where the employees are not in close quarters. There are other workplaces where vaccination is considered or may be considered to be essential. And these are pretty obvious. So healthcare workers, teachers, and retail workers. Just another couple of factors here as well. So one thing to consider is the duty to accommodate. So employers can impose a mandatory vaccination on an employee who has a medical condition or a disease that makes it more dangerous for them to receive the vaccine. And also employers cannot impose a mandatory vaccination on employees who are a member of a religion that objects to vaccines. Case here from 2011, actually, at the Human Rights Tribunal, in the context of a different vaccination, where the HRTO found that the employee's general objection to vaccinations did not amount to a creed under the code, and there is one decision which I'll get to in a moment, which is important. Another factor is employees' right to privacy. I won't focus on that too much. I'll go through some of these decisions, but as I've said, I'll provide a chart afterwards. So the first one that I have here, and this was when there were only arbitration decisions. There's now at least one court decision. A lot of good guidance from the arbitral decisions in the unionized workplace context. So there's the United Food and Commercial Workers Union decision at Paragon. That particular vaccination policy was upheld. In that case, the collective agreement stated that if the security guard stationed at a third-party site and had a mandatory, if the third-party site had a mandatory vaccination policy, the security guard must be vaccinated or reassigned. Paragon then, the employer then implemented its own mandatory vaccination policy, and the union agreed this. The arbitrator, as I've said, held that the policy was reasonable and that Paragon had an obligation under the Occupational Health and Safety Act to take every precaution reasonable in the circumstances for the protection of its workers, and also the policy aligned with the collective agreement. There was also, towards the end of 2021, the Ontario PAR and the Generation of Power Workers Union decision. That policy was upheld. This was related to a bit of a niche issue about gyms that the workers used, and the arbitrator held that these were obviously high-risk areas for transmission because of high-touch surfaces and increased potential for close contact. The arbitrator also took into account the fact that the Ontario government mandated that public gym users were required to be vaccinated at that time. There's also the Electrical Safety Authority decision from 2021. This policy was actually held to be unreasonable and unenforceable. And in the context of this decision, before there was a mandatory vaccination policy in place, the ESA had a voluntary vaccination disclosure policy requiring anybody who was unvaccinated to submit to regular testing. Arbitrator in this case held that the policy was unreasonable and cannot be justified. This was because most of the ESA's employees were still working from home, which was permitted by the collective agreement, and there was therefore no significant risk of transmission. I'll just skip on to the next slide. So another fairly early decision was the Bunn-Hamilton Canada decision. And so in this case, the arbitrator found that the policy was reasonable, did not violate privacy rights, and was a reasonable exercise of management's right to issue workplace policies. The factual findings are here as well. So if the arbitrator said if the employer had not implemented the policy, it would not have been able to properly operate its business because of a leasing obligation or leasing obligations they had with the Port Authority. Another factual finding was that unvaccinated employees create a known public safety and health risk for vaccinated and unvaccinated individuals. Thirdly, unvaccinated employees were able to work remotely for this employer. Other issue was that the policy did not provide for automatic disciplinary suspension or termination. It basically just said that unvaccinated employees will be placed on an unpaid leave, so not fired. And number 5, the fifth factual finding, so a policy allowing for testing as an alternative would not have been reasonable, as it would have resulted in a breach of the Port Authority requirements in terms of the lease obligations between the employer and the Port Authority. And just going to the notes, there are some more recent decisions here. One of them is from the federal court. So in this case, the appellants were seeking an injunction to prevent the implementation of the federal government mandatory vaccine policy, which I mentioned a few moments ago. So Justice Fothergill looked at this issue, and you can see from the quote there that essentially what the judge said was that, simply speaking, a vaccine mandate does not cause irreparable harm because it does not force vaccination. And also said that the employees were not being forced to get vaccinated, they were being forced to choose between getting vaccinated and continuing to have an income on the one hand, or remaining vaccinated and losing their income on the other. One last case I would just like to mention is you can see this in the notes. So this is the Crope and Viewpoint Systems decision from 2003. This very recent decision in which the Ontario court surprisingly find that an employee's refusal to comply with a mandatory vaccination policy is effectively a frustration of contract, meaning the employment contract can no longer be performed by the employee. And this is one of the first cases to confirm that a refusal to become vaccinated can lead to a frustration of contract. And unfortunately for the employee, the effect of this was that they had no severance entitlements at all, not even their basic ESA minimums. So hopefully I haven't skipped through that too much, and we have a bit of time for questions.
We're getting a lot of great questions in the chat, so I will start with reading those. What happens if an employer chooses not to accept a medical note and exemption and still chooses to fire an employee rather than accommodate them?
Okay, so apologies. I'm assuming that a medical note has been provided in terms of a medical exemption from taking a vaccination policy, and that's what we're talking about.
Yes.
So that's, I mean, that's a very difficult question. So, I mean, the employer will, and this sort of goes back to human rights considerations and accommodation. So there's the procedural component. Both the employer and employee are expected to participate in that. I'm finding that my own practical experience that most employers will deny the medical exemption, and there are actually no cases to my mind where a medical exemption has been granted in terms of a vaccination policy.
Okay, thank you. Next question. Are there any cases about the fact that the federal government is asking people to repay more than the amount of CERB they received?
I am not aware of any decisions on that. I mean, I know that I've seen from the various news stories that the government is asking people to pay back those payments. Probably doesn't fall under employment law, although I'm certainly not aware of anybody who's being asked to pay back more. I can't see why anybody would be expected to pay back more. My focus in terms of CERB has been on whether it's deductible or not, but ultimately it's up to whatever government agency is involved to make a determination. I suppose it's CRA in terms of whether it should be repaid. But I'm not aware of any decisions. They're probably tax court decisions, I would think, if there are any. It's probably too early, given that this has only started happening now, and one of the effects of the pandemic was that the courts are very backlogged, so I doubt there are decisions. And certainly if there are, I'm not aware of them.
So we're getting a lot of questions about constructive dismissal. One of the questions we have, are you finding many of the constructive dismissal cases are being settled before going to court?
I am finding that a lot of them are being settled. And I'm finding that a lot of them are being settled post the decision in Taylor and Hanley from the Court of Appeal. I was not litigating too many of those cases. I find them a bit risky, to be quite honest, on the employee side at least. But since the law was resolved, in my opinion, after the Taylor and Hanley decision, or non-decision, depending on what your view is, Coutinho and Fogelman are still good law, and those cases by and large are settling. I've heard anecdotally and in my experience as well with some of the cases. That was the at that point in time after April of 2022, the Taylor and Hanley decision was when there was a lot of movement. A lot of people were waiting to see what was going to happen with Taylor and Hanley.
Another question about constructive dismissal. Does constructive dismissal preclude an employer from relying on the termination term in an employment contract?
Absolutely not. So it's the same sort of analysis for a constructive dismissal and a wrongful dismissal in terms of what the damages are. So the first thing that any employment lawyer will look at is your employment contract. They'll look at the termination clause to see whether it limits your entitlements to the Employment Standards Act minimums, or if there's no employment contract at all, we know that you're entitled to common law reasonable notice. But if there is an effective termination provision limiting the employee to Employment Standards Act minimums, that's what they get if they are constructively dismissed and also wrongfully dismissed.
So we're also getting a lot of questions about vaccines. So this one is asking, what trends in settlements have been observed in situations where workers have been dismissed because of their refusal to get vaccinated, but have then been offered their positions back after the employer rescinded their vaccine policy?
So I guess there are a couple of issues there. I mean, I'll provide the chart after in terms of the decisions. They were most of the policies were upheld as being reasonable. So, the employees were losing out in terms of that. Has it affected settlements? I mean, I think employers, generally speaking, if they're going to mandate a vaccination policy, they, forgetting about the legality of it and whether it's going to be upheld, they generally speaking don't want to make exceptions. So if they make an exception for one person, then they have to make it for others. So generally speaking, in my anecdotal experience and what I've been hearing from other people, employers were sticking to their guns with the vaccination policy.
Has an employee sued their employer for mandatory vaccination against their will? Is there a legal standing for such claims?
I'm not aware of anybody suing their employer for being forced to be vaccinated. And, we have to be careful about, I'm not trying to cause any political issues or anything like that, but in my opinion, and we've seen this from one of the cases that I talked about towards the end, people were not being forced to be vaccinated in terms of being fine and being forcibly vaccinated. People had a choice, which is fair enough. It's not a great choice to have to make, but employees have a choice. You get vaccinated, or depending on the employer, you may be put on an unpaid leave, which is a hell of a lot kinder than being fired for cause. I think most reasonable employers would take that approach, as opposed to just firing someone for cause. I have not litigated those cases because, again, I find them too risky. On the employee side, which is most of what my practice is, although I do represent employers as well, I have not seen any cases being litigated where the employee later rescinded their vaccination policy. But I'm aware of situations where the vaccination policy was rescinded and the employee was offered their job back. And then the question becomes, is it reasonable for the employee to mitigate their constructive dismissal damages by returning to work? All right, and the big decision, or the governing decision on this, is the Evans and Teamsters decision. And so and the question, as most questions in employment law, is what's the reasonable thing to do, or what would the reasonable person do? And so that's essentially what the test is there as well. Would a reasonable person go back to work? I think it would be a tough argument that you were, as an employee, so offended by the mandatory vaccination policy that you simply can't go back to work. I think that's a really tough sell. And if there are people litigating those cases, best of luck to you.
We have a related follow-up question. What can be done when an employer withdraws an offer of employment because the employee won't get vaccinated?
There are certainly cases, I've definitely settled cases where this is a sort of similar situation. Doesn't involve a mandatory vaccination policy, but basically what happens is, it happens often, and if an employee is offered a job, they're still working with employer A. Employer B has offered them a job. The employee quits their employment or resigns from their employment with employer A, and then employer B suddenly says, "Oh no, we don't have a job for you anymore." So the short answer is yes. I don't think it would be any different just because of the vaccination issue. But again, it depends what your damages are, right? What are your damages if you haven't yet resigned, for example, from employer A? Well, your damages are nothing. But this example sounds a little bit different because I'm assuming that this employee doesn't have a job and they've been offered a job and they've accepted it. And then later the employer tries to impose another obligation on the employee in terms of mandatory vaccination policy. So yeah, I mean, I think they would have a claim. Yeah. Wouldn't necessarily litigate it, but it's definitely worth sending a letter to the employer and asking for damages.
Okay, that's good to know. We have time for one more question. This one is on the employment side and has to do with earnings. Are there any cases of note in which the quantum of variable earnings has been calculated differently due to the impacts of the pandemic? For example, if a bonus pay was low in 2020, would the calculation period be changed?
That's a good question. Actually, I'm not aware of any cases. I mean, generally speaking, leaving the pandemic aside, I mean, in terms of bonuses or commissions as well, or other variable pay, typically what the courts will look at are they'll take an average of, let's say the last 2 or 3 years as an indication of what the employee would likely have gotten during the common law reasonable notice period. That's the general approach that the courts take. I mean, obviously, it's a lot harder to do that if the employee has been only employed for a short period of time. So if they've been employed for a year and a half and they've only received one bonus, I mean, you're really only looking at that bonus. But the law on this issue is, and I'm glad somebody asked that question, because there's a case that I litigated in the Supreme Court in 2019, which is the Matthews and Ocean Nutrition case. And among other things, that decision was about bonus payments that come due during the common law reasonable notice period. So it leads me into that as well. The question really is, what pay in terms of all of the employees' compensation, where are they likely to get during the common law reasonable notice period? And so in terms of calculating it, like I said, it's usually based on an average. The pandemic, I mean, it's too early to have seen any decisions specifically on that very narrow point. But I would expect that given the courts have already are already attuned to the issues of the pandemic in terms of extending the reasonable notice period and also mitigation, I imagine that the courts will take judicial notice of the pandemic. And obviously, where someone is variable pay, I mean, let's say someone is a salesperson who only earns commissions and that's it. If their business was shut down, obviously they're getting no commissions. So I think that has to be a consideration.
That's all the time we have for today. I'd like to thank Sean for speaking with us and all the attendees who joined. If anyone is interested in purchasing a copy of Sean's book, Employment Law During a Pandemic, it's available on the LexisNexis e-store at lexisnexis.ca/store. And Sean, I'll turn it over back to you if you have any closing words.
Yeah, sure. I just wanted to say thank you again for inviting me to do this. I was very excited to write the book, although it was a lot of work. I expect and hope that there will be a second edition of it coming. And if anybody does have any more questions for me, I have to put my contact details up on the final slide. And you can feel free to reach out to me by phone or by email. Happy to chat with people about any employment law issues, especially pandemic related issues.